Hi everybody, my name is Maureen Redspock. I've decided to do my final presentation on pregnancy discrimination in the workplace. I chose this topic because I feel that pregnancy discrimination is not a form of discrimination that most people think about when they talk about discrimination in the workplace. Another reason I chose this topic is because I've experienced pregnancy discrimination firsthand, but at the time I wasn't even aware it was discrimination. Pregnancy is usually a wonderful time in a couple's life, but sometimes this happiness is overshadowed by discrimination. But what exactly is pregnancy discrimination? According to the U.S. Equal Employment Opportunity Commission, pregnancy discrimination is treating a woman, either an applicant or an employee, unfavorably because of pregnancy, childbirth, or a medical condition related to a pregnancy or childbirth. The harassment of a woman because of her pregnancy is also a form of pregnancy discrimination. Unfavorable treatment can involve any aspect of employment, from hiring, firing, pay, promotions, layoffs, training, fringe benefits, and any other term or condition of employment. When a company is hiring, it is against the law not to hire a woman just because she is pregnant. Many companies attempt to justify not hiring a pregnant woman by saying that they only want to hire someone who is able to continue to work without any interruption. This is illegal. When an employer fires someone who is pregnant because they do not feel like that pregnant woman can do her job anymore, that is also illegal. It is illegal to pay a woman less or not to give her a pay raise because she is pregnant. It is not the employer's right to decide whether a woman can do her job or not because of a pregnancy. That's between her and her doctor. The not giving a woman a promotion because she's pregnant is also illegal. So who can be found guilty of pregnancy discrimination and who can be discriminated against? Employees and coworkers, both male and female, can be guilty of pregnancy discrimination. An employer is guilty when they deny a woman a job, fire them, or do not promote someone because of a pregnancy-related condition. A coworker who continuously makes comments about a woman's pregnancy or harasses her about her pregnancy or breastfeeding is considered pregnancy discrimination. Any woman who is, was, or will be pregnant in the future can be discriminated against. Harassment by coworkers is something that I personally have experienced. When I was pregnant with my fourth child, my coworkers would constantly ask me if I knew what caused my condition. One even offered to buy me a television, as my husband and I obviously had too much time on our hands. I should say all my coworkers were female at the time, so I didn't really think this was a form of discrimination. These little jokes, they continued throughout my pregnancy, to the point where, when I was out on my FMLA leave, I decided not to go back to my job. I'd been working there for almost 10 years. In 1978, Congress passed the Pregnancy Discrimination Act, which was an amendment to the Civil Rights Act of 1964. The amendment made it illegal to discriminate based on a woman's pregnancy. Under the law, discrimination of current, past, and future pregnancies are covered. An employer could not force a worker on leave if the worker was still able to work. But prior to the PDA, women could be fired for anything pregnancy-related. Teachers in the United States have mostly always been female. And before the passing of the PDA, teachers could get fired, and often did, for getting pregnant. Can you imagine your boss letting you go just because you were pregnant? Unfortunately, for many teachers, that is exactly what happened. Another issue that women had with pregnancy discrimination was a forced maternity leave. It was not uncommon for an employer to require a pregnant woman to take her leave 5 months prior to her due date. Employers felt that when a woman was 4 to 5 months pregnant, she was in a delicate condition and couldn't do her job anymore without putting herself and her child at risk. In a 1973 lawsuit from Cleveland Board of Education versus LaFleur, that was the first lawsuit that actually challenged mandatory pregnancy rules pressed upon pregnant teachers. In that school district, if a teacher did not take her leave at the designated time, it was grounds for her dismissal. The Supreme Court ruled in favor of teachers, finding that forcing them to take a maternity leave was unconstitutional. In this finding, they ruled that making the assumption that all women who were 4 to 5 months pregnant were physically incompetent was a violation of the 5th and the 14th Amendments Due Process Clause. Not all lawsuits based on pregnancy discrimination prior to the PDA were successful, though. In 1976, General Electric versus Gilbert, in this case, the Supreme Court majority ruled that excluding pregnancy from comprehensive disability was not sex discrimination because pregnancy was not a condition facing all women. With this decision, the Supreme Court established that plaintiffs had no claim of pregnancy discrimination under Title VII, leaving women only with a constitutional claim. In that, the plaintiff had to prove discriminatory treatment or of a discriminatory purpose is why she was fired. This opinion was not of Justice Stephen, though. Justice Stephen wrote a dissent attacking the reasoning of the majority, and Congress agreed with him. Congress agreed with the statement that Stephen made that, by definition, such a rule discriminates on account of sex, for it is capacity to become pregnant by which primarily differentiates the male from the female. This case ultimately led to Congress passing the PDA in 1978. After Congress passed the PDA in 1978, women in the workplace did have more protection from discrimination against pregnancies, but it wasn't perfect. The PDA's second clause, as passed in 1978, dictated that pregnant women be treated the same for all employment-related purposes as other persons not so affected but similar in their ability or inability to do work. In other words, it did not give a pregnant woman any rights for accommodation in the workplace. It wasn't until the ADA Amendments Act of 2008 where the ADA scope potentially covered qualified persons with disabilities and pregnant workers with pregnancy-related disabilities. Although the government has passed laws to prevent pregnancy discrimination, it is still occurring today. In 2017, the EEOC reported that 3,174 pregnancy-related discrimination cases were brought to them. Some of the cases today brought to court involved blatant discrimination. One case that I saw was from 2007, where a maternity clothing chain fired a saleswoman when she became pregnant. It's crazy that an industry that caters to pregnancy would discriminate against someone who was pregnant. Even with laws and regulations, pregnancy discrimination is not going away. We need to make sure that lawmakers need to continually monitor pregnancy discrimination and the